Well, hello and welcome again to the Disability Law Show. Good to have you here for the half hour. John Scholes with me, Tamar Agopian, courtesy Samfiru, Tumarkin LLP, the most positively reviewed law firm in the country. You have disability law woes. You want to reach out to Tamar anytime. I'll give you that number right off the hop. I'll give it out throughout the show as well, but 1-855-821-5900. help@disabilityrights.ca. That would be your email address. And simply disabilityrights.ca, that website, there's a media page there as well under Knowledge Center, right? If you go there, you'll find a link to our long-running radio shows as well across the country. You can tune into a station, perhaps call in on a show at your leisure, ask some questions. Your phone call might appear on a later show right here, so get to that when you want. Again, 1-855-821-5900, the number to reach Tamar and her team anytime. The main topic in just a bit, 3 common myths about insurance adjusters. We love talking about them, Tamar. We're going to do that here in just a bit, but we always start off with a case of the day or a week that was. What do you got, pal?
So I would be remiss if I didn't highlight the top of our show on the case of the day. And it's one that's actually, that we had spoken about on our show previously. It's a case involving a woman who actually took her claim all the way through to a jury trial in Ontario and was very successful against the insurance company. It's a case called Baker and Blue Cross. And in this scenario, she was in her 50s. She had had a stroke and a lot of long-standing lingering symptoms that stemmed from that stroke. And her treating neurologist was called up to trial to testify. It was in front of a jury, which is why we have a reported decision, John, on this. And she won. She got full benefits paid into the past and back onto claim going forward, and a whack of punitive and aggravated damages, $1.5 million in punitive damages and another $40,000 in aggravated damages. Very significant. One that we're really looking through to see what were the underpinnings, how do we leverage a case like this going forward? But most importantly, why I'm featuring it this week is because there's now a second decision that's come out of this one where there's a ruling by a court on what costs are to be awarded in favor of a claimant, the individual who was successful at trial. In Ontario and in the other jurisdictions that we operate in, including Alberta and British Columbia, this is typical. You will have the trial decision, and when you're successful, you'll have a second decision that talks about what costs get awarded. And she was successful again and got almost another nearly $1 million in. It's unprecedented, though.
Yeah.
So for those viewers who are watching, this is unprecedented dollars. This is not typical of disability claims, but it's an important one because it highlights the fact that disability litigation is very risky. You want to have the right representation. You want that representation to give you the right advice about moving forward with a claim. And you want to leverage that against the disability insurer for them to also understand how risky and costly litigation can be. And I think that's really the best part of this decision, John. If we think about the impact of it, I think that it will really hammer home for disability insurers how risky and costly litigation can be, and therefore favor even further what we more often than not do, which is to get a settlement quickly for our clients. And if you read the decision, the costs one that is, the court really focused on the risks involved with an individual who was denied disability benefits, denied benefits for years until it got to a trial, and improperly denied by the disability insurer, and then ultimately was successful. And the courts recognized that that financial risk for a claimant who's not getting their LTD benefits and has now had to hire a lawyer to fight this, well, then that should be compensated for, and then some, is in essence what the court has said. So I think this decision is really a landmark one, a good one. Do we think it might get appealed to the Court of Appeal? We don't know. We're going to keep an eye on it. That's part of what we do for our work and for our clients. But I think it's a really helpful warning shot to some extent to other insurers to say, hey, if you're not making the right choices, you're going to pay the price down the road. And we're ready to act for our clients on this basis as well if we needed to, because we all have trial experience and our team to do these kinds of disability legal claims.
Well, like I said, it's a large amount, but what was leading up to this? What was the whole case about? Can you talk about that? What was like, why
Absolutely.
did it go this far?
Well, so it went this far because the disability insurer was intransigent about it it, they were emboldened by the fact that they had an independent medical assessment that they had done of her, and they were relying on their hired gun to move this forward through to trial and say, okay, our hired gun then we think is going to be recognized above your own treating doctors as the expert to comment on whether she is totally disabled from working, and at this point in any occupation, in any setting. So that was one element of it. The other element was the insurance company had done something like 13 hours of surveillance, John. And so, you know, we talk about this from time and time again about surveillance and how insurance companies will spend the money on doing these kinds of surveillance efforts, because really what they're trying to do is find some kind of smoking gun to discredit a claimant and use that as leverage to cut off the claim and dissuade them from actually moving forward in this type of manner. But the court wasn't persuaded, John. In fact, this is what I think the basis of the censure was against the insurance company, was the fact that they had relied too heavily not only on a hired gun, but surveillance that was not all that persuasive. And the court preferred the treating doctor's information and evidence and opinion that this individual was never going to work again, or most likely was never going to work again, and found in her favor in a big way.
We've talked about surveillance in past shows, Tamar, that it's very costly for the insurer to do so they wanted to yield some fruit, and they're going to try as hard as they can to pick something from there. But if there's nothing in 13 hours that works for them, that can really be a booby trap for them as well, because that 13 hours is better for you.
It is, actually. And, you know, in the end, the amount of time proportionally that they had observed her in the things that they thought she was doing that was inconsistent with what her medical evidence was disproportional. I think in the end, the court only allowed 2 of the 13 hours anyway. And so what I like to emphasize to our viewers and our listeners when we do our television and radio shows is, just because there is surveillance and the insurance company has gone down the road of obtaining this kind of information doesn't mean that's the end of the line for your disability claim. If they've relied upon it and they've cherry-picked the kinds of things that they wanted to rely upon to bring the disability claim to a close, and that's not necessarily inconsistent with what you've reported to your doctors or what your doctors are saying about your ability to work, then it's just not all that persuasive. And we see that really come through in these types of legal decisions that are really favoring the claimants in disability litigation.
You've often said, if you know, it could be 13 hours, it could be 1,300 hours of surveillance. If you're doing nothing wrong but what your prescribed, you know, things are from your doctor, you got nothing to worry about.
Exactly.
Right? It's unnerving if you know about it, but if you don't know about it, you've got nothing to worry about.
It is. And I think what's disappointing is that a lot of people get discouraged from bringing forward their disability claims because they are either worried that this is going to be an ongoing thing, or they don't really want the insurance company to take a step like this and have them watched. It's actually not that common, and I don't want individuals to feel discouraged that this is something that happens all the time in every element in every claim. But it also, I think the key message here is that it's also not something that's as persuasive as your adjuster or your disability insurer wants you to believe if it's in line with the activities you've already reported to the adjuster and to your doctors. So I think if you do come across an issue like this, John, we're only a phone call away. If people are concerned, you know, just give us a call. Any member of myself or my team, we're happy to talk you through and see if there's some options, if the surveillance is the basis as to why the disability insurer has denied your claim.
Mentioned a couple of websites off the top in contact to reach Tamar and her team. There's also another one called pocketemploymentlawyer.ca. You're thinking, okay, wait, I've heard that website. I've seen it used on the Employment Law Show, our sister show, but there's an element inside that website, Tamar. You do both, of course, but in this case, it's disability law, and why that website's handy for you guys as well. Right?
It is. So we like to have these tools, John, because Pocket Employment Lawyer in particular does have a disability feature as well, in the sense that you can go into it anonymously. You can plug in some additional information to see whether or not you have a basis for a further conversation or a legal claim for your disability claim. Of course, it'll give you some helpful information on your employment as well. But you're right, we do both of these elements at our firm, and this tool itself really exemplifies that. And so what I want to encourage individuals to do is, look, if they're not ready to have a full conversation with a lawyer, that's absolutely fine. But this tool is really, really good because it's not like we're going to call you afterwards. You can just put in the information, get a little quick response, and then you close out your browser and we're none the wiser. But if it does signal to you that it's something that you should probably have a further discussion with a lawyer, then at least it's a starting point for individuals to get that information along with a whole host of other really helpful information on our websites.
Again, pocketemploymentlawyer.ca is that website. Let's get to an email before we take a first break and get into our main topic for the day. help@disabilityrights.ca. You want to use that each and every time. Mateo's our guy, says the insurance company recently referred me to a rehab consultant for my disorder and, without my doctor's knowledge, put on a return to work plan. This new program has aggravated a lot of my symptoms, and I feel my stress levels have increased. Am I allowed to opt out of this plan? What do you think, Tamar?
Well, so the starting point with this kind of email from Mateo is, what does the policy say about these types of rehabilitation plans? And that's really where I wanted to start speaking and addressing Mateo's email. Most of the disability policies that I've seen, John, will have a section that says if the insurance company wishes you to undergo some kind of rehabilitation, then they will mandate that in their policy. And if you don't comply or participate, if the insurer thinks you should, then the consequence of that is that they will disentitle you from disability benefits. That's a fancy way of saying, if you don't go, we're going to cut you off.
Yeah.
Okay? And so, unfortunately, in Mateo's situation, I think that he does need to continue to cooperate until or up to the point where perhaps it's medically not safe for him to do so. So what do I mean by that? So if you're wondering, look, I'm on a return to work plan, how is this put in place without my doctor's input? That is a problem for the insurance company, no doubt. And so you yourself want to engage your own treatment providers, get their opinions around what it is that the rehab plan consists of. Can you possibly get this type of treatment elsewhere with a treatment provider that's a bit more arm's length than the one that the disability insurer has paid for and set you up with? And if that transition can be made, I think then you can resist a little bit better the insurance company's dogged efforts for this return to work plan. The bottom line, though, is that this is a pressure tactic. And we talk about this on our shows, John, that insurance companies want to put you on these types of return to work plans without consulting with your doctors because they want to pressure you back to work.
Sure. Get you off claim.
That's exactly right. They will get you off claim if that is ultimately where it ends. And frankly, if they're on this path anyway, whether you choose to participate or not, if you don't participate, they're going to cut you off. If you do participate, their provider will no doubt conclude that you're good to go and you can work, and they're going to bring that claim to an end either way. This is why they spend money on claims like this, to do these types of rehab plans and set up these policies in a way where they tie your entitlement to benefits to the plan. What I don't like is the aggravation that Mateo describes. I think no treatment plan should have an aggravation of health issues, and it's important that his doctors are aware and they actually comment on that in some kind of a medical report that he can then submit to the insurance company to say, hey, this is doing more harm than good. I really should not be continuing on this treatment plan going forward. I will continue to participate, but we really need to cooperate here because it's setting me back 3 steps and it's not achieving the goal that you want me to achieve, which is to get back to work.
So initially, when the insurance company, whether it's their rehab people or the one that Mateo chooses to go to, that first step of him having to go to rehab, that's all part of mitigation on his part. So that's why you're saying he's kind of got to go forward with it?
Well, so mitigation, this is an important legal concept where individuals, either on the disability side or frankly even on the employment side, this is a legal principle where people have to take positive steps to get better and recover, at least in the disability context. So yes, they have to show that those efforts are being made. They can't simply just take their monthly benefit and then sit back and just wait for the benefit to be paid without moving towards meaningful treatment efforts and trying to get to a point where they can get to back to some sort of work setting. Having said that, though, this is why I focused on the aggravation aspect of it, is that if it's doing more harm than good, then it's not helping anyone. Frankly, not the insurance company, right? And definitely
100%.
not Mateo.
Yep.
So I just would prefer to see the conversation switch towards what's in Mateo's best interest as opposed to the insurance companies.
Love it. We'll take our first break, a short one. When we come back, 3 common myths about insurance adjusters. That is on the way. In the meantime, that phone number to reach Tamar and her team, 1-855-821-5900, help@disabilityrights.ca. That's the email address, and we'll continue with more of the Disability Law Show. Stand by. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks so much for sticking around. The Disability Law Show again this week. I'm John Scholes, Tamar Agopian, Samfiru, Tumarkin, LLP. To reach out anytime at your leisure, we always advise you to do so and have that initial chat. It won't cost you anything, just to say hello and talk about what you want to talk about with Tamar and her team for sure. 1-855-821-5900, help@disabilityrights.ca. That's the email address we use every week on the show. Okay, Tamar, let's get into this brass tacks. 3 common myths about insurance adjusters. Number 1, adjusters are well versed in every aspect of a claimant's file and condition.
How many times can I chuckle? John, I'm going to chuckle a little bit, and I was chuckling when we were looking at this topic because there are so many myths about these adjusters. And you know, I spent a little bit of time at one of these big bag insurance companies in my career, and I can tell you that the adjuster role in particular, it has a lot of turnover. It has a lot of turnover because it's typically an entry-level job for most insurers.
Good call.
And it's frankly one where there just isn't a lot of training. You'd be surprised how little training most of these adjusters get, not only on how to apply policies, how to deal with disability claims, but most importantly, they have zero medical training. So the vast majority of them are, university graduates or perhaps making their way through the career in the insurance industry and really don't have a lot of sophistication in dealing with disability claims. I think the comment that I hear the most, John, is the lack of empathy. I think that, the lack of experience with these adjusters, and you couple that with a job that frankly is quite challenging, given what they have to do, lots of caseloads, and frankly their job is to close out claims. That's the perfect storm. And so you can't assume as a claimant, when you're dealing with your adjuster, that you're dealing with the type of sophistication or any empathy for your disability claim. They're very focused on crunching those numbers, getting through claims, meeting their targets, meeting their quotas, and moving on to the next one. So big myth in terms of the kind of individual that most people are dealing with their disability matter.
And most of them have a stack like this, so it's it's like the person who sees your bill when you're leaving Costco. Yep, keep going. Yeah, keep going. Okay, nice talking to you. Keep going. They don't have time.
Absolutely.
They're going to miss things.
And they're trained very focused on process. So they have to do the little phone memo. They have to update the computer system. Yeah. Those are the kinds of things that they are more focused on than a meaningful connection with the claimant to truly understand what their symptoms and issues and conditions are and how that relates to the disability claim that they are adjudicating. Because again, I go back to the idea that they don't really have a lot of medical training. Most of these adjusters will actually use a web-based guideline to help them figure out when they put in certain symptoms that you have or perhaps a diagnosis, that what the duration of that claim should be, or how long should they expect that you're on claim, what are the typical treatment measures. So when you're going into this as a claimant, if you're listening to our show and you're wondering, how is it that my adjuster doesn't understand how depression works or how anxiety works, how chronic pain works? Not surprising, because they are using, Mr. or Mrs. Google to go online to actually help them navigate the adjudication of these claims. And you just can't assume that they know all, and frankly, typically they know very little.
Sure. Insurance adjuster common myths. Number 2 is this, Tamar. Insurers can behave in any manner with claimants throughout the claims process.
Nothing could be further from the truth, John. I mean, I was talking about it at the top of the show about punitive damages, aggravated damages, and that really is driven by the idea that there is a duty of good faith. These adjusters are expected to treat you with respect. They are expected to listen to you and actually take a fair approach with your disability claim. I hear too often that individuals feel quite harassed sometimes by their adjuster, that they feel that the constant emails and the phone calls and the tone in which they're being treated is just too much. And I tend to agree that it's unfettered because they don't actually have someone above them listening into the phone call they're having with you, or perhaps even supervising what this adjuster is doing in handling your disability claim. Now, I'm not suggesting that in every instance it should get before a judge or a court, but I think that if you're struggling with dealing with your adjuster, certainly there are tools. You know what comes to mind is we've got a really helpful memo on one of our websites, ltdfaq.ca, on dealing with difficult adjusters. If you're wondering how to deal with it, just take a quick look at that memo. It's extremely helpful, and it will give you some guiding points as to what is the quote-unquote normal in a situation like this. And most certainly, it should never border on the negative. It should never be so much so that it's aggravating your health issues. And if it is, I think it's absolutely appropriate to either get your doctor involved or perhaps tack on a manager or someone who's, more senior than this adjuster to say, these are my dealings with this adjuster. It's not productive. It's taking away from my health and the appropriate advancement of my claim. And this is not something that I can continue to deal with.
Adjuster myth number 3. Let's get to our third one tomorrow. When the insurance adjuster denies your LTD benefits, their decision is final and you can't take any further action. That's it. You're done.
No.
No.
So that was an easy one in the sense that, look, the disability insurer wants you to feel as though it's a final decision. They will typically initiate some kind of a phone call to say, hey, your benefits are coming to an end. We're going to give you this letter that says your benefits are ending. This is why, for any number of reasons, maybe true or untrue. And what is problematic is that at times they will say, we have now closed your file. This is our final decision. And individuals feel as though that's the end of the line. It absolutely is not. The moment that the insurance company has denied your claim, John, it crystallizes your right to start a legal claim.
Good call.
And I want individuals to, at the very least, give us a call and have a conversation with us for that option. What does that mean for your disability claim? Where are you at from a health perspective? Because I can assure you that if your doctors are still supporting that you are not able to work as a result of your health, then those benefits should continue. And just because the adjuster has said, this is our final decision, or you can appeal, now you've tried an appeal a couple of times and now have been declined again, and your claim is so-called closed, doesn't mean that's the end of the line. Nothing could be further from the truth. But if you do give up, then you are leaving money on the table. If you don't assert those rights, then I feel as though the disability insurers' profit-making machine is actually working. So the words are important, but what's most important is what your own doctors are saying about your claim.
We'll take a break. Another website when we come back, we'll go to it, as a matter of fact, called mydisabilityquestions.com. Does exactly that. You can ask questions. We'll tackle that on the other side. In the meantime, 1-855-821-5900 and disabilityrights.ca. We'll continue more of the disability law shows coming up.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Disability Law Show. Let's go. We got lots more to go through here. MyDisabilityQuestions.com. I mentioned that website before we went into break. MyDisabilityQuestions.com. That's a beauty because you can use your tablet or your cell phone or your desktop for that matter. You can type in your questions to Tamar and her team, and that's it. There's also a searchable database. That's how it was constructed. So maybe a question similar to yours has been asked and answered in the past. It'll save you some time. If not, use it at your leisure and ask your questions. One from Leon. Again, mydisabilityquestions.com. Tamar, Goes like this. My claim for LTD was approved, but I was laid off from my job. I'm now worried the insurance company will cut off my benefits as a result. And I've recently caught COVID, which has made the healing process more difficult. Do I have to be employed to continue receiving the disability benefits?
Really good question, Leon. I'm glad you reached out. There's actually a couple of elements here that I want to touch on.
Yep.
The first part, and directly, because, you know, I get this joke a lot. Why don't lawyers ever answer my question directly?
No.
And the question is, do I have to be employed to be entitled to LTD benefits? If Leon has been approved, which he says to us that he has, then no. He does not have to be actually job attached or employed while he's continuing to receive his benefits. The reason for that is because just because your disability claim may be tied to that employer. In other words, LTD plans, the ones we mostly talk about, are group disability plans. They are, you know, part of a funding of a group of employees with the same employer. If you lose that employment though, but your LTD claim was already initiated before that employment was lost, then you have coverage and you are absolutely entitled to those benefits. But there's a little bit more here. He mentions to talk about the layoff, this idea of being laid off. Let's say Leon hadn't initiated his disability claim, John, before he was laid off.
Gotcha.
You know, does that close the door on LTD? It's a little bit more complicated, but not necessarily is the answer to that, because sometimes you will have disability coverage or extended health coverage through a layoff period, or you are terminated and still have benefits protection, at least in Ontario, for the statutory notice period. So without getting too much into what my colleagues will speak about on the employment side of things, I want individuals to be aware that if they have a disability claim that arises in that window of time, the door is not closed for disability benefits. But you must initiate that claim.
Right.
You want to make sure that it's started during a time where you have coverage so that you don't find yourself in a situation where the insurance company is using a technical reason to deny your claim. A technical one would be you're not covered, you're not eligible,
right,
or perhaps you weren't actively working in the time immediately before you started your disability. And in fact, the only reason that you're proceeding on disability is because you're not working and not because of your health. So I think that's an important caveat to this email from Leon. And the last thing, of course, I'd be remiss if I didn't touch on this idea of COVID and what does that do to a disability claim. We are still seeing insurance companies resist any claim that has any mention of COVID.
That'll be a while.
And I think it will be a while because no insurer really wants to be the first one to take a COVID claim to trial and have a judge say this is a valid disability claim. Again, like I said at the top of the show, these risks are high for disability insurers. So what they're trying to do, I think, is resist these types of claims, you know, sort of close the perceptual floodgates of potential claims on COVID. But if you're Leon and you started your disability on one health issue or certain health issues, and you later developed other health issues that are persisting your symptoms, then it's important for all of that medical information to be made available to the adjuster and the insurer so that they've got a whole package, all of the medical information that's the basis of the claim so that those benefits continue on all the health issues.
And to your point, the element of this whole thing of being on disability, it's not what got you there, it's the fact that you are disabled. It could be a head cold, a broken wrist, or COVID. That's not the point.
Exactly. And so it's really important that the idea that it doesn't matter what the diagnosis is.
Right.
Frankly, it doesn't even really matter what the treatment plan is. The key is, do you have restrictions and limitations that prevent you from doing your job, regardless of whether you're job attached or not? And if your doctors are saying you cannot work, then you're absolutely entitled to LTD benefits in those circumstances.
So basically, just because you got a job, you paid into the program, even if you're off, you still qualify for it. They're two separate things. Insurance company and your employer are two different people.
They are, exactly. And so I think that unfortunately what happens is that individuals get confused when they are looking at a job loss or a layoff and not certain what's happening with benefits coverage. It's important to get clear information from your employer so that if you do have health issues, you are moving forward with that application and not losing that opportunity to do so and get those benefits that you've probably paid premiums for.
And that is it for another show. Appreciate you reaching out, Leon, especially you at the end there, mydisabilityquestions.com. You want to carry on that conversation with Tamar, invited to do so. 1-855-821-5900, help@disabilityrights.ca as well. And we'll catch you next time on the Disability Law Show.